So okay.
So we had talked about question 1C, yeah? Did you do the drafting?
I was trying to look for which question it was. I didn't do the drafting, but I had the structure of the content of what we are supposed to do. Because I was trying to think which question it was, and I looked at the messages. It showed 4 to 6. So I looked for it. I couldn't find it, Madam. Apologies about that. But
Okay.
we can draft together if you don't mind. But I
Okay.
found I read the structure of really what you need to have as the structure for the security agreement, which is the first one, of course, is the parties. You have to be able to list the parties clearly. You have to list, perhaps in the recitals, you have to list the intention or purpose of the document. And in this case, you would be saying that the purpose for the document is to secure a loan. Then after you've done that, now the next bit you do is you write about the secured obligation. So the secured obligation here would be the loan.
Yes.
And you indicate the amount. And I was wondering, because what I wanted guidance on is, do you write, and I tried to check various security documents. It doesn't separate. It doesn't separate the interest or the principal. And because the concept of loans is that the security amount, the secured obligation is not exactly the same value of the loan, it's always a lump sum. And most of them, you find that they're 20% above what the security is, especially if it's non-cash. And like it's a truck that is depreciating, it will be above. So assuming, if you look at the question here, it doesn't quite say what the amount is. No, it
It
wasn't
does.
clear on what the amount was.
Yeah. So
Yes.
there's somewhere we called about in an exam scenario.
Yes.
This is even drafting. Any drafting you are going to do, even in criminal, civil, litigation, probate.
Yes.
You know there are something called I call adding fact. You can add your own facts which does not conflict with the.
Okay.
Yeah. Yes, which does not conflict with the question. So amount must be the amount must be in a security agreement. So it is for you now to put the amount. Yes.
Yes. Okay. So you put now a fixed amount, let's say 10 million. And
Yes.
then for the security, you have to mention what the security is, and you have to be descriptive, because
Yes.
if you look at MPSR, the relevance of being very descriptive as to what is being secured, that then you can register it, is very critical. So, so you'd go to the tracks, each track, the plates, you would, the unique number in a vehicle is the chassis number. So you perhaps have that, and the title, the reference of the title document. Then there you would have, there's this term that is called, so you'd have, I think, equivalent to what you call terms and conditions. instances in which this will be triggered, and then the process of how it's going to be triggered. And then is any standard contract, you always have to have breach, impact of breach, and now the standard applicable law governing law.
Yes.
And then the signature pages, the signature blocks. Yes.
So that is good. I think it captures everything. And of course, you should be mindful of the
time,
the time of time
and the marks.
Yes, time and the marks. So you draft a very small document.
Okay.
Very small document. In fact, here.
What would you draft, Mwalimu, in this case? Because it's just 5 marks.
You just put the parties.
Parties.
I want to project a document here.
Okay.
So this is a sample chattel. Sample chattel mortgage, which is of course is secured credit under the old Chattels Act. You remember is the one of the act that was repealed by the movable. So in an exam scenario, if you are given marks, 5 marks, in fact, that's why I wanted you to draft. I see how you have drafted and the time you have taken. You see, drafting is a skill, the structure and the content, because you can be able. You see, you can be able. You can be able even to draft a document, but you use a lot of time, which is, of course, you are losing another question. No. So time is very, very important than structure. So you draft very quickly. So of course you call you name it.
Yes.
The heading, you call it a security agreement between.
So, Mwalimu, question. Do you have to title it in the way you've titled it? Is this how it's usually titled?
No. I'm saying this is an example of an agreement. Chattel mortgage.
Okay.
You see, security agreement is usually for movable properties. You know that, And a chattel mortgage, like now here it was a harvester, John Dee harvester. You know the harvester, Yeah. So this was under the repealed chattels, which was repealed by the movable properties.
MPSR.
Yes. So the heading, we call it security agreement between Kano, Keno Sugar Limited.
Keno Sugar, yeah.
Keno Sugar Limited, and who are their creditors?
Their creditors.
Local bank.
Not listed.
So local you give bank, it a local bank. You give it a name, So you can say then KCP. These are the facts I was saying. You add.
You add. Okay.
You add, because you can, in an exam, you cannot say a local bank. It must be specific. Specific. In drafting, must be very specific.
Yes.
So now you describe the parties that you have said. In brief, Keno Sugar Limited is a private company used in importation and milling of sugar. Importation and milling of sugar. Unaona? You don't even need to. You don't need to put even the post bio box. So the most important one is the guarantor. No. The grantor.
Yes.
So that
The
is the word
wording,
that
the wording of grantor, grantee.
grantee. So that is the most important
Okay.
thing in movable properties.
Okay.
So the bank, you call it KCB, is a bank in Kenya called the guarantee. That introduction is enough.
Mm-hmm.
Now go to the loan. You can jump even
The recital.
the recital. You can jump. You go to the loan. That is another
Okay.
most important thing.
Yes.
So the guarantee hereby advances a loan facility of shillings 20 million payable as per the terms of the loan agreement to be secured by the tracks. You know, here they are talking about the tracks,
Yes.
and the tracks, you give them name as very specific as you said. You get
Mm. Mm.
the higher. Then the amount secured, principal, interest. The amount secured by the mortgage shall be aggregate of principal amount or interest from time to time payable to grantee at no cost. So you must say that.
Mm.
Then you go to the grantor's covenants.
Mm-hmm.
So here you put like two most important thing.
Okay.
Yeah. So the grantor has the right and full power to assign to the grantee the
chattels.
security. Yeah,
Yes.
the security. Yeah. That is one. The next is the guarantor will pay the guarantee the principal money and interest hereby secured. Yeah, you must guarantee that. Your
Mm-hmm.
covenant as a guarantor.
Ah, okay. Okay. Understood.
Yeah. You must say that.
Yes.
So what are the powers of the guarantee? Very, very important. That is another clause. If in default made by the guarantor in payment of the principal, the money hereby covenanted to be paid in the day, what happens? So what
Okay.
usually happens? You apply your knowledge on the act.
Yes.
Yeah, so they will enter upon the land of the premise where the charter for the time be subject to security may take possession.
Yes.
So
These are the
they have,
keywords.
yeah, they take the possession in default. Take possession
Mm-hmm.
and sell or dispose.
Yes.
The tracks. Then another very, very important clause is discharge of the security, the securities.
Yes.
So what happened? Upon the final balance of the money secured having been paid or satisfied together with all interest due, after paying everything,
Mm-hmm.
yeah, the guarantee so what happens under the how is the discharge of security done under the movable property security?
Sorry?
How is this discharge of the security done?
I think on my reading, it's not different from what is written here. Question. See. Sorry, I'm writing to Helen the question that we are doing. Sorry. So it's not different.
Is discharge. You can, I think it's
Yes.
the guarantee signs the discharge.
Yes.
Yeah, it's very, very important. We look at that. Because you know you can be even be told to draft a discharge of charge.
Oh, okay.
Yeah, so let's look at
Just write that discharge of charge.
yeah, MPs. In the companies, BRS,
Yes.
in BRS, they are very good documents.
Yeah, the handbook.
The handbook is very good.
Mhm.
So there is usually registration of the notice.
Mhm.
That one you can, there is a security agreement, there is a registration notice, it is registered under in the BRS,
Yes.
under the movable property security rights.
Mhm.
But I want to know how do you discharge?
Through cancellation.
Mhm.
It's a cancellation notice that is provided.
What does it say?
So it says that Section 29 of the MPSRA, it says the registrar shall assign a unique registration number to a registered initial notice and associate all registered amendment and cancellation notice that contain that number with the registered initial notice. So think if we are then doing this security document under the MPSR, it may be important to indicate that part of the powers that the grantee will have is to make such registration and issue. Yeah, the grantee to make such registration, and on discharge, when you're talking discharge of the chattel, then a cancellation notice.
Yes.
To be issued, because that's how we do. Because it says Section 33 says compulsory registration of an amendment or cancellation notice. The secured creditor shall register an amendment notice if the registered notice to which it relates contains information that exceeds the scope of grantor's authorization or the security agreement to which the registered notice relates has been revised to delete some collateral. So the secured creditor shall register cancellation notice if the one that we want to look at, the security right to which the notice relates has been extinguished, and the secured creditor has no further commitment to provide value to the grantor.
Very good.
So this is the Section 33 is the process of cancellation. Yes.
So yeah, that is what we include here. Unaona?
Yes.
And all those things, you look at you look there at if there's something you can be told to draft there. Yeah, be aware of anything, because you see, in the question, you see one of the question they ask last time, they ask, we are going to reach them, they ask about disclosure letter. It's one of the letters that is involved in the initial process of mergers and acquisitions. So all those things that can be drafted. You see now, in March, I told them they can ask about security agreement. Unaona it came. So I'm telling you, this is a prediction. Anything small around MPC, this movable property, those notices. Yeah, go and practice how to draft them.
Yes.
Yeah, Yeah, they can ask you.
Notices.
So
Okay.
yeah, anything that is needed, those initial notice and cancellation notice.
Yes,
So this
Mwalimu.
is what you this is what you include in the discharge of chattel. You include how the right to be extinguished by cancellation. Then governing law. So the governing law is a Movable Security Rights Act. Then you sign in witness whereof the parties duly executed instrument this year, sealed by the said grantor, and then witnessed by an advocate, sealed by, then guarantee, sealed by, then the advocate witnesses. So this sample charter mortgage, it is in the notes, under commercial notes in the website. It is there. So you
when
capture the
you're
most.
drafting for 5 marks, you
Yes.
perhaps would you then be shooting for like maybe a page?
It's not a page. You capture the most important thing, the most important elements.
Okay.
You were there when I was talking about the minutes you should use to do a question. Are you there?
I've read the notes on how to do the exams, but I wasn't there in the first meeting.
So yeah, so also let me share this for these purposes.
Asante.
So these are document I prepared from my called doing by exams. I can project. I will share it later after the class, because this is drafting is a skill. So here I say, let's go to, yeah. So yeah. So here, that's why I usually like people to draft, so that I can see the content at the time they have taken. They indicate there. That's what we are doing with the last year people. All this drafting. So exam is there 6 questions of each. First 15 minutes read the questions and choose one you do. For compulsory question have 20 marks. Use 50 minutes to tackle it and 25 minutes for the 4 others. 15 last minutes used for proofreading your work and finishing the question you did not finish. Remember, not necessarily the compulsory attracts 0 marks in the whole paper, notwithstanding the 4 question. Yeah, so if it is a question of 20 marks, use 50 minutes. So you time yourself. If it write that down. So if it is a question of 25 marks, you use 13 minutes. Yeah. No, if it is a question of 20 marks, you use 50 minutes. If it's a question of 10 marks, use 25 minutes. If it is a question of 5 marks, you use 13 minutes. Yeah, so this question you are supposed to use around 13 minutes.
Yes.
And you capture the content, the content. So if you had drafted and you indicate the time,
I would have known how long it takes. Okay.
what it takes,
I will still do the exercise. I will still do it for my own benefit. Yes.
Yes. Yeah. So let's go to the next question. So as it fortunes continue to deal, Kano Sugar Limited has no option but to sell some of its vast land at 200 million shillings. It had bought the land 10 years ago at 100 million shillings. The legal fees and other incidental costs related to the transaction stand at 17 million. The company has erected a fence and some buildings on land amounting to 5 million shillings at time of purchasing the land. it has paid its lawyer 3 million shillings in legal fees. Calculate the capital gains. This is 1D. So these are calculating capital gain tax. Is usually tested in conveyance. It has never been tested in commercial. So I wanted to see your calculation also. Yeah.
So
you can attempt.
there is, okay, let me do it quickly.
Yeah.
And my colleague Helen has joined.
Yes. How are you, Helen?
I am well, labda nyinyi.
Tuko sawa kabisa. So you can do your calculation also, eh?
Okay.
Yeah, and say what you are. I want to see. That's why I was. Yeah, I see how you have calculated.
I've gotten 20,100,000. Yes. Is that correct? No, it's not. It doesn't appear correct.
So one thing I want to advise you, go with the electronic calculator, the one that you go with the LPM to do this thing. You can't do this thing with your biro. Yeah, so go with carry your calculator in conveyancing, commercial, LPM, because you may be called upon to do calculations.
Yeah. I've found the gains I found is 134 million. I've calculated 100 million, the cost, 17 million, the value addition, and the 5 million and the 3 million. So the total came to 124 million. So if they are selling it for 250, yeah, so it would be, so 117.5, 121 plus 3, I found 124. So the difference is 134.
Yes, so?
Is it 134? Sorry, 136. It can't be 134, 136.
So you know lawyers are not very good in maths, eh?
Apparently.
Yes, even me, I cannot say, even calculation, I cannot say that I'm very good, eh?
Yes.
That's why I don't teach people accounts. So, but we can try to do it together.
Yes.
So you start by, in a question of 5 marks, eh? You start by saying what is capital gains, eh? This is a document by KRA, which I'm projecting, eh?
Yes.
Yeah, capital gains tax, frequently asked question. You can get it at their website. So gains, capital gain tax is gains which are accrued to a company, individual, or partnership on after 1st January 2015 on transfer of property. Yeah. You start by saying that the rate is of CGT is 15 of the net gain. So that is another very, very important. So how do you compute capital gain tax? Net gain. So I want you to now to take your I want you now to take your Bible. I'm not going to give you the answer.
Okay.
Yeah, you calculate. Net gain is net gain, which is equal to transfer value minus incidental cost on transfer minus adjusted cost, which is acquisition cost once incidental cost on acquisition plus any enhancement cost. So net gain, transfer value. What was the transfer value according to the question?
250 million.
So write 250 million.
Okay.
So what was the incidental transfer amount?
Incidental transfer amount was 17 million.
Very good. Incidental cost on transfer, 17 million. So what is 250 minus 17 million?
It will be 233.
233. Now,
Yes.
let's now calculate the adjusted cost. So adjusted cost is acquisition cost. What was the acquisition cost?
100 million.
Yeah, 100 million. So what was the incidental cost on acquisition?
Incidental, we have done it, the 17 million at the beginning.
Incidental cost on acquisition.
It's 3 million, the legal fees.
It's 3 million. Very good. It's 3 million. Because they paid the lawyer when they were acquiring.
Yes.
3 million.
Yes.
Yeah. So
and
what is
then
the what is the enhancement cost?
Yes. 5 million.
Enhancement?
5 million.
5 million, which they built the fence.
Yes.
So what is total? 100 plus 3 million plus 5 million?
The total is 92 million. No, sorry, plus 108.
108.
Yes.
So 233 minus 108?
13 minus 8, 5, 2, 125.
125. And CGT is 15% of the net gain. So 15% of the net gain?
So 120. So let me just do it on the calculator. 125 times 15%. 18,750,000.
So that was the answer, Yes.
Why is it different? Why is it different? Because what I had done previously is I'd done 100 plus 17 plus 5 plus 3. We should end up to the same thing.
Yes.
It wasn't 136, it was 120 something. Okay. I see my error.
Yes, you have seen your error. Yes.
Yes.
So to get this 5 marks, first of all, you define what is capital gain tax.
Yes.
Then the rate is 15% of net gain. That is the second point. Yeah. So net gain. What is net gain? Is then you say what net gain is. Transfer value minus is net cost on transfer into bracket minus adjusted cost, that is acquisition cost, and is net cost on acquisition plus any enhancement cost. Then you do your calculation and give your answer. You get your 5 marks.
So you don't go straight to the calculation. You step it. Okay.
Yes.
Okay.
Yeah. It will give you more marks, eh? So this is a capital gain transfer. Frequently asked questions. I urge you to go and read it, eh?
Yes.
On KRA website. And this, I think, was a straightforward question, eh?
Yes.
So we go to the, and I told you, but you carry a calculator.
Yes.
So we go to question 4 now. So I'm going to read question 4. Let me project. Yeah, question 4. Jengainchi Limited is a private real estate company limited by shares, which is adopted model of company Metas. The company nominal capital is Kenya shillings 100,000, which each share valued at 1,000. Incorporated in 2015 by the late Richard Kumo. Jenga's directors and shareholders are the adult children of the late company founder, and up until recently, they have been able to peacefully coexist with the rest of the day-to-day running of the business. The directors, shareholders of the company are David Kumo, shareholder, 10 shares, Ruth Kumo, director, shareholders, 35 shares, and Cynthia Kumo, director, shareholders, 35 shares. A market specialist by trade, David is very keen on the company, cozy on a 50-acre parcel of land situated on NRL 1/2023. Having received a judge bankrupt, much to the chagrin of his sister Rose and Cynthia, David believes that the company's next project can be designed around the parcel of land of his own volition. He even started putting up billboards marked mixed use development coming soon. Reserve your plot and now and Jengainchi. David is confident that the advertised project will change the fortunes for the better, and he proceeds to call an annual general meeting of the company in this way, with the next 7 days for the purposes of electing David Kumo on director of the company and appointing him as a sole signatory under the seal with authority to enter into agreement for the sale and purchase of ARA number 102/2023. As a company secretary, with aid of relevant provision of the law, critique the notice issued by David. So, Helen, you have not spoken, eh?
Yes.
So try to interpret this question. Eh?
Okay.
So what are the key words in this question? This is company law, of course. Eh? So what are the keywords that I'm going to are going to help you answer this question?
Okay, in the question, it is evident that there are three shareholders. There are three shareholders to the company. One of them has been declared bankrupt.
Very good. That is a key, yeah?
Yes, one of them
has been declared bankrupt.
Yes, David has been declared bankrupt. And when you go further, you see that he seeks to be made a director.
Yes. Yeah, that is good interpretation.
Yeah, he wants to be part of the management of the company.
Yeah. Yeah. Because he's a shareholder, eh?
Yes.
Not a director. So you want to be made a director?
Yes.
So In fact, the question is clear. It's the director shareholders of the company. All of them are director and shareholders. So he has been declared bankrupt.
Yes.
Then another thing very, very important in this question, helping you to answer, Kate, the other thing.
Sorry, I didn't get the question, Mwalimu.
I'm asking you,
Uh-huh.
we are trying to interpret this question.
Yes.
Of course, this is a question on company law, private company.
Yes.
One of the things you have been told, David have been declared bankrupt.
Yes.
And is a director. That is key to the question. Then what it is the other thing?
So on the same line, because when I was looking at this question, what came out is David having been declared bankrupt, what can he do? What can he not do with regards to running of the business?
On that bit, of course, we are going to discuss. There is another thing very, very important in this question. Even if let's imagine, just presume that David even has not been declared bankrupt. What is the other thing?
So the other thing is the notice of calling an annual general meeting.
Very good. So the other thing is
the notice is not ordinarily 7 days. I think it's longer.
So the question is also testing your knowledge on the notice. How a meeting is called by directors in a private company. The annual general the general notice. So you need to have the knowledge on that. So now, as a company secretary with the head or relevant provision of the law, critique the notice issued by David. So you can now answer the question with those two things in mind. So critique the notice issued by David, Helen.
First, it has to do with the timelines within which this meeting is supposed to be held.
Even before you go to timelines, even before you go to timelines, what is the position of a director who has been declared bankrupt?
Anyone who has been declared bankrupt is usually prevented from participating in the management of any business, just being part of management of anything at all. They cannot participate in the management of companies. They cannot be directors. Yes. So
without leave
David,
of court.
Yes, without leave of court. So he's incapacity. He lacks the capacity to be appointed as a director.
Yes. So they are talking about relevant position of the law. What is the relevant provision of the law in section 223? 2231.
Okay.
Yeah. Yes. Another very, very important section on this is section 311. Section 3011A of the Insolvency Act. It is an offense for acting as a director when you have been declared bankrupt. It is an offense. Section 3011A. So those are 2 points. Now we go to the general, the notice. Kate, what do you think?
Sorry. So So that then I follow. You said the first one is a director who's been adjudged bankrupt cannot continue in the role of directorship. Was that the first point?
Yes, that is the first point.
Then the second point is
without leave of court,
without leave of court.
And the section there is section 223(1), subsection 1 of the Companies Act.
Company Act, okay.
Then it is an offense to act. It is an offense to act as a director when you have been declared bankrupt. That is section 301, subsection 1A of the Insolvency Act.
Insolvency Act.
Yes.
Then the other one, an annual general meeting requires 21 days notice.
Yes. Which section is that?
I'm trying to look for it.
Look at 275.
But 275, yes, 275A.
A1.
Just go to it. Every company shall convene meeting once a year. That doesn't have the time. That one doesn't have the
section
time.
281, 281(1).
281(1). Yes, in convening a general meeting, a private company shall give 21 days notice. Yes.
Yes. And he has given how many days?
7 days.
7 days. Look at your section 281(4) and 5. What does it say?
So a general meeting may be convened by a shorter notice than that otherwise required if it is agreed by the members. The shorter notice referred to is valid only if it is agreed to by the required majority of members.
Yes.
So here, I think the fourth point is that unless the other shareholders agree, the meeting is invalid. Yes. Then the other one is, I think the request of what he's asking to be appointed as a sole signatory to enter into an agreement is point 2, where he can't because it's now an offense. I think, are we then now having 4 points?
Even there are more than that.
Agreement. Okay, let me see if there's anything. The only other one perhaps would be
there's another point. There's another
purpose.
point. I hope, Helen, you are noting those. There's another point.
Yes.
Look at section 285 of the Companies Act. Context of the notice. What is the context of the notice? You can read. I can project. Yeah. So what is the context of notices of the general meeting? You know, a notice must contain, yes.
Contents of notices of general meetings. In giving notice of a general meeting, a company shall specify the time and date of the meeting, the place of the meeting. In the case of a hybrid or virtual meeting, specify the means of joining and participating in the meeting and the general nature of the business to be dealt with at the meeting.
Yeah, so what is it, the violation here, according to this notice?
There's no time.
Yes.
Wait a minute, let me find the paper.
Let me project. Yeah, you have it.
Yes. There's no time. Yes, I have it. There's no date. There's no place. There's no indication whether or not it's going to be a physical meeting or a virtual meeting.
The only thing he has
However,
included is the nature of the business.
Yes.
Yes, to be appointed as a signatory. Yeah, authority to enter into a said agreement and to be appointed as a signatory. Unaona?
Yeah.
So are we together, Kate?
Yes, Mwalimu.
So this question of general notice and special notices, these are repeated questions. Yeah, they are in the past Q&A. The only thing they introduce here, so you fine tune also on special notice. This was on general notice. Okay. Special notice, what is the time required? Yeah. And the only thing they introduced here was a bankrupt director. And I've told you, nothing has been tested on public companies. So that is a fertile area. Even conversion has not been tested. Not even a question. Conversion of public to private. Yeah, all those the conversion that they are there in the Companies Act. Okay. So David has been granted, question 4B, David has been granted leave of court to be appointed as a director of the company, and his siblings have agreed to transfer 5 shares each to David for the company to allow 10 shares to David, so as each director shareholder will have 30 shares. Proceed to draft a dated memorandum to the directors spelling out required documentation to affect the desired changes. Yeah, so you draft a memorandum.
Is in this case, I looked at it, the memo is equivalent to sort of like a legal opinion, like you're stating the steps to be taken.
Yeah, so you do it like an internal memo, eh? So you do get like an internal memo. So you are the company secretary. You say from your name, the company secretary, then to all the directors.
Yeah.
So what do you think, Kate?
So the first one is that there will need to be a resolution. Then second, they need to enter into a transfer, to sign a transfer of shares document. There is a form provided for, I can't remember what form number it is, but there's a share transfer form that will then need to be undertaken and indicated whether it is for value or no value. That is whether he's going to pay the cost of the shares. What I think is not clear, if there is no value, whether stamp duty, like what you classify as stamp duty. So then the other thing would be, we would need to update the register of shareholders to update the current status, and then issue the shares now to the relevant parties. Those are the documents I think top of mind. Yeah.
Yeah, so that is very good. That is a front. That is on the part of transfer.
Yes.
And of course, everything is done at BRS website. Eh?
Yes.
After the transfer, share transfer is done. Eh? I think I have a share transfer somewhere, which you can be told to draft. Note that one.
Okay.
Yeah, it's a company, other companies. Yeah. Yeah. So let me project because this can come. These are share transfer. Of course, I'll share it. Yeah, share transfer agreement between transferee and transferor in respect of 250 ordinary shares held in share transfer agreement. So you talk about this share purchase agreement is you talk about the parties, the transferor, which is the director, and transferee is David. You talk about which the shares are being transferred. So purchase price, if it is a consideration, yeah, then the other obligation of the party, and I can share it after class. You will look at it.
Yeah.
You remind me. So, but there is another second bit called allotment to this question. Because you see, the directors are going to transfer 5 shares to David, and the company will allot. So that is the second bit of this question. Process of allotment. So the form to be filled is called CR20. Yeah, so we can look at it. BRS website has all those forms. Yeah. So there are all those forms, companies forms, which are needed to nini. So this is I can project the form. They're in the BRSC website. Return on allotment. So name of the company, particulars of the allotment, number of shares allotted, payable in cash, nominal amount of shares allotted. Yeah. So full names of the allottee.
How come when you say, so where do you write the names of the sisters? Is it in the particulars?
The particulars.
The name of the sisters, because the allottee is David, right?
It is a company, the allot which is allotting. It's not individual.
If you look at the question, it says that the shares for the sisters. Oh, understood.
Yeah.
So that
The
then now all the directors, but the sisters had 35 shares. So, but it's saying after this happens, each director and shareholder will have 30 shares. So where do the 5 shares for each of the siblings? Because you see here it's saying that as the director of the company and his siblings have agreed to transfer 5 shares each to David.
To 5.
So 5 shares each and the company 10, so that then everyone has 30 shares. David had 10.
Yes.
So got 5 each from the company, sisters, 10 from the company and 10 from the sisters.
Yes.
So where do we write the information of the sisters? Will that be an allotment or a transfer? So the 5 shares, the 10 shares from the sisters will be a transfer, and then the company will be the one allotting now the 10. Is that the case?
Yes.
Okay.
Yes.
Okay.
You have understood, eh?
Yes.
So there is the allotment part, eh?
Yes.
And this is a form to be filled, eh? By the company, eh? Allotting the 20 shares, the 10 in here to David, eh? Yeah, so that is the process, eh? So allotment is CR20 form, and the reverse section is section 3.1, and then the transfer, of course, is what you had, Katie had talked, eh? And you get your
5 marks.
So this area of transfer and allotment, that is a new area never tested before. I encourage you to look at all the forms in the BRS website, and you can be told to draft. Eh?
Okay.
There is also a document called Combined Company Procedures in the BRS website. Eh? Combined Company Procedures. It has all the procedures and the forms. Eh?
Okay.
In fact, I can tell you with certainty that a question on the procedures of company will come. Any procedures that involve a company will come. That is a compulsory question. So read that one. Eh? Yeah, we can go to the next question, question 5. So I want to project. Mabati Steel Limited and Steel Kenya Limited are privately owned companies, both engaged in business of steel manufacturing in retail. Steel Kenya Limited is wholly owned subsidiary of Steel World Limited, a holding company based in the Republic of Rwanda and which generates 90% of profits of conglomerate within Rwanda. In a bid to expand the industrial base, the parties have agreed to merge their businesses in order to expand the industrial base. It has been agreed that the Steel Limited, being much larger, successful entity with 50 market share, shall be the acquiring undertaking, while Mabati Limited with 5 market share will be the target undertaking. The gross combined annual turnover value of assets of parties amount is 50 million US dollars. So this question is asking you on which topic, Helen?
Mergers.
Mergers and acquisition.
Yes.
Eh? So it is when you see merger and acquiring and merger, this one merger, you see acquiring and target, acquiring and target. So you know it's acquisition, mergers and acquisition, which is usually not a very easy topic. So Mr. Kai, a director of Steel Kenya Limited, has engaged your services and wishes to know whether or not the proposed merger is exempt from notification to the Competition Authority of Kenya and whether it meets COMESA regional dimension threshold test. Please explain by highlighting the relevant provisions of the law. So there are two key words here. Where the proposed merger is exempt from notification to the competition, CAK, and whether it meets the COMESA regional dimension threshold tests. And you must answer your question with the relevant provisions of the law. So, that is how you interpret the question. So, Kate, you make a try.
Briefly explain. So there are several components that are checked when determining whether a merger is registrable or is notifiable, reaches the notifiable threshold. First, within the local, there's the within the local, and in this case, the Kenya one, it is the current market share within within the sector. And if it has majority shares, I think it's usually from, I'm not very sure of the percentage, but I would say for this question, Steel Kenya if there is any acquisition, whether they're acquiring or being acquired, they will meet that threshold because Steel Kenya has 50% of the market share, and Mabati Steel has 5%. So it would meet the notifiable threshold. Then from a COMESA perspective, the requirement is whether the combined gross turnover is 50 million and above. And in those instances, they meet. So, so it does meet on both accounts, and they would need to notify. So on the first one is the COMESA, guidelines on mergers and acquisition would apply, and in this one is the competition. There's a competition, if I'm not wrong, Competition Act that then would apply. I don't know. It's a shoddy attempt, but
so it is a competition authority,
yes,
which deals with mergers and acquisition.
Yes.
So you have made a very good attempt. So what are the exemptions from notification? Because that is the first part of the question. Taking place wholly or entirely outside of Kenya, which has no local connections. Yeah, but in this case, this company is a Rwanda company and a Kenyan company. So it needs to be notified.
Yes.
So the other exemption is where the combined turnover assets, whichever is high, of merging parties in Kenya does not exceed 500 million or $5 million US, which of course this one, it is more, it is $50 US.
Yes.
Then on COMESA guidelines, COMESA guidelines, you can look at, it is called Rule 4 of the Rules of Determination of Merger. Yeah, when you are touching on companies, on member states, companies which are merging or acquiring, which are outside Kenya, member state of COMESA, and this one of these companies from Rwanda. The combined annual turnover of value of asset, whichever is higher, is to a merger is equal or exceed 50 million, and the annual turnover of value of asset of which of at least of two parties to a merger equals or exceed 10 million. Yeah. So that was the answer. Eh?
Yes.
So it needs to be notified. So this question is repeated again. It was asked in March. Exactly the same thing, and it has been repeated in November again. The exact thing. Eh? So what does that tell you? I told you when you
it might come.
When you know, it means when you see a question that is repeated directly from the previous paper, directly in March, now it is asked is November. You can look at question 1A of March. You see it. It means that the student has not been able to answer it well. Many failed, eh? And I can understand why they failed, because these are very difficult area to understand all these figures or what you are talking. Eh? Yeah, so it might come again. Eh?
Yes.
So a disclosure letter is usually written by the seller to avoid future claims and also help the buyer to completely understand the transaction at hand so that they can make a truly informed decision. Draft a sample disclosure letter for purposes of presenting in your merger and acquisition class. So this commercial question has had a lot of drafting. Eh?
Yeah.
It had security rights agreement. Now this is a disclosure. Draft a detailed memorandum. That is another drafting. Eh? So they're asking a lot of drafting, and commercial agreement topic. Drafting commercial agreement is one of the topic. So expect more drafting coming. So disclosure letter. So I know you did not draft. I usually like you draft and you send me. Yeah, I see. But since you did not do that, let me project one I have here. So this one I got online. Eh? Yeah, so it is just a disclosure letter. A disclosure letter is commonly document used in mergers and acquisitions to assist the buyer with due diligence report. This document takes place from letter in form of a letter from seller to buyer. Provides the buyer with general specific information that will inform the decision about whether to proceed with the purchase of the business. The disclosure letter provides the seller with an opportunity to update the purchaser with any changes of document or previous information that requires updating. So, 2, disclosure letter. So it's 2, name of the buyer. Of course, you can put the details of the seller. You know, it's a normal letter. So the seller here is target undertaking is the seller, eh? And acquiring is the buyer. Eh? So target
Yes.
undertaking is Mabati Steel. So it's from Mabati Steel to Steel Kenya. Yeah, so it's Mabati Steel to Steel Kenya. Yeah, date you put the date, sale and purchase of the entire share capital and asset of Mabati.
So Mwalimu, in this question, they are merging. No one is acquiring the other. Or it has been agreed that Steel Kenya Limited, being the much larger and successful entity will be the acquiring undertaking.
Yes. When you see acquiring and target,
Mabati Steel having 5% would be the target undertaking.
Yes.
Acquiring
and target undertaking.
Steel Kenya. Understood.
Yes.
Understood. Okay. So Mabati is the buyer. No, sorry. Yeah, Mabati is the buyer. Acquiring undertaking, while Mabati will be the target undertaking. Mabati Steel Kenya Limited is the acquirer.
Yes.
That is the buyer. Mabati Steel is the seller.
Yes.
So this will be the seller, Mabati Steel, doing the disclosure letter.
Yes.
Okay, understood.
Yes, so that is it. Yeah, so from then the subject is sale and purchase of the entire share capital of Mabati. Yeah. So dear sir, this letter is written in reference of sale and purchase agreement proposed date with today's date and entered in between. So between Mabati and Steel. Yeah. So the letter together with document listed index attached to it, disclosure bado, is the disclosure letter referred to the agreement. Words expressed defined shall have the same meaning using where the context permits. So reference in this letter to the accounts of the company shall be audited. So what do you include in the disclosure letter?
So I think
this is the disclosure letter. The disclosure letter provides the seller with an opportunity to update the purchaser with any changes of documents or previous information requires updating.
Yes.
So you can talk about accounts. Reference to this letter of accounts or company shall mean audited. Yeah.
You also list any changes in the company that have been undertaken by the company, like during the negotiation period. Then you also indicate liabilities and claims that may be there, and if perhaps they have agreed on, like, because some contracts indicate that you only disclose if a liability exceeds a particular amount. You indicate any litigations. Yeah. I think generally, and there's also another one I saw that you indicate, because they're acquiring business, if there are special conditions of agreement that would trigger on change of ownership. I think that becomes also a disclosure you make that, say, for example, if you change ownership of a company, you risk a particular contract, or you have to notify your suppliers or certain of your suppliers or your clients. Then you indicate if there's been change of directorship, anything to do with employees that has changed, but you do the disclosure letter just before you sign the share purchase agreement or the sale agreement, and they'll have undertaken due diligence. So anything that has happened between that time is what you disclose. I think that's what I would say.
Yeah, that is good. That was good research. So that just saying that in an of course, if it is an exam scenario, of course, a disclosure letter, a letter you do it the way, the normal way you do a letter. But I know the challenge could have on the content, which you have talked about. So, on this, go and look at two things, which has not been tested on mergers and acquisition, which I'm suspecting it might come. Number one is the complete process of merger and acquisition. Number two is drafting of a merger and acquisition agreement. So process of merger and acquisition, the complete process, and drafting a merger and acquisition agreement. Merger and acquisition topic, I usually find it not an easy topic. So be prepared well, because it can come even as a compulsory one. Yeah, so we got to one last question of this paper. Benki Yetu Leading is a leading microfinance institution operating in Kenya and neighboring countries. Its target market is undeserved rural women population in agriculture sector. Benki Yetu successfully applied for receiving a 5 million grant named Bri Economy Grant for Rural Women Empowerment. The institution has advertised for grant in Bri Economy Frontiers based in the United States of America. In order to implement the grant, Benki Yetu is expected to register women community CBO in 10 different countries. In order to qualify, the countries should board a freshwater lake, and CBOs should be involved in fish farming business for the period of not less than 5 years and have a total of 100 members and is led by women. In addition to the official document, the CBOs are expected to submit full names of each member, including their age, sex, marital status, ID, and PIN numbers. Upon complying with Benki Yetu submits its information to BEF, who then authorizes sub-granting in form of interest-free loan to CBOs. In recent past, a member of one of the CBOs have written a letter to Benki Yetu to complain about the transfer of personal information outside Kenya without complying with the relevant law. Fearing a legal suit, Benki Yetu have approached your practice with a leading data protection firm, seeking a clear legal opinion explaining the condition for transfer of data outside Kenya and the safeguards applicable to prior to transfer of data outside Kenya. Yeah, so this is a straightforward question. It is a legal opinion, so you do a legal opinion. Conditions for transfer of personal data outside Kenya and safeguards applicable prior to transfer. Yeah, so you can make an attempt, Helen.
I think before any information by the members of the CBO is transmitted from them to the ones who are going to be handling the information, there has to be consent. Yes, there has to be consent to the
consent by
consent by the members of the CBO. They have to know the extent of the information that they are supposed to give. I believe they should also, in case the information is to be transmitted elsewhere, they should also be informed of that, so that anything outside of the parameters that have been set amounts to an offense. I think that's, that's all I have to say about that for now.
Yeah. So the relevance, you know, this is one of the question I don't like, because this is not a purely commercial question. This is not a commercial question, by the way. This is not purely a commercial question. There's somewhere you read about data protection in commercial, Kate.
I think I remember discussing it in class. In a commercial class.
The question or
the topic.
Or a topic.
The topic,
under commercial.
Yes, we did data. We did data protection. It was discussed in class. But we also handled it when we were doing legal drafting and writing.
Yes. Yeah. So the relevant section is section 48 and 49 of the Data Protection Act. So which I think I'm projecting the act.
Yes.
So a data controller or data processor, of course, you must know who a data controller or a data processor. In this question, is this benki yetu?
Yes.
So they must be.
Benki yetu is the data controller. BEF is the processor.
Yes. So data controller, data processor is given to the data commissioner appropriate safeguards with respect to security and protection of the personal data. So they must give the safeguard to data commissioner. That is one point. So they have given B. They have given the data commissioner that is point number one. Then the transfer must only be necessary for the performance of the contract between the data subjects, which are these women. Yeah, and so that is in the second point. So the processing of 49.1, the processing of sensitive personal data out of Kenya shall only be effective consent, what Helen has talked, from the data subjects, these women. So that is the third point. May transfer data to another country to demonstrate effectiveness of the security safeguards or exercise of compelling legitimate interest. So the final point is that the data 43.3, the data commissioner may order or protect in order to protect the rights and fundamental freedom of data subject prohibit or suspend or subject the transfer to such condition that may be determined. So those were the 5 points. You get your 5 marks from section 48 and 49. So, Kate, you run this topic under which, commercial, under which topic in commercial?
I remember it was a discussion that we had on data protection in a commercial class, but we then did it in a project, a scenario. Yeah. So that's how we interacted with data protection.
Okay. Yeah. So that data, to me, it is not a purely commercial question, but this is a question that applies even in civil litigation. It can apply in many subjects.
Yes.
Yeah. So it's good. You are tested at a project about this. So this is one of the questions that if I was doing this paper, I could have. Okay, it will depend on maybe part B. Yeah. So let's go to the last question of the day. So, Sipatosasa is a private foreign company that is incorporated and has registered offices outside Kenya. In a bid to capitalize on the burgeoning cross-border business of virtual currency trading and investment and keen on exploring the Kenyan market, Sipatosa has established a branch office locally. 18 months after incorporation, Sipatosa is able to develop a payment system in support of business model, which payment system was recognized by central bank. Unfortunately, the have received communication to the effect that the business of Sipatosa on its country of origin have been placed under liquidation and the liquidator has been appointed. The company now seeks your advice on whether they will be able to continue utilizing the payment system locally and what the steps the local officials need to take in compliance with the law. Analyze the relevant provisions and advise your client. So Helen, interpret the question.
So CryptoSasa is a company that has its head office outside of the country, but it also has a branch within the country. So the parent company is going under liquidation, and there is a crisis as to the operations of the branch within the country. So the problem has to do with whether or not the branch that is in the country can still carry out operations in the country despite the parent company being under liquidation in the foreign country.
So what do you think? Now answer the question.
Okay. From the research I did, though I can be corrected, found that the parent company may be undergoing liquidation, but because this other
no. You see, let me correct you. The foreign company has already been placed under liquidation. Yes. And the liquidator has been appointed.
Yes.
They are not undergoing. They have already, the parent company has already been liquidated and liquidator appointed. So now answer.
Okay. Okay, from what I managed to see, I can be corrected.
Yes.
That a parent company is undergoing liquidation in a foreign country may not necessarily interfere if the operations of the subsidiary are going on independently, of course, it's generating its own income, then the liquidation of the parent company will not interfere with the operations of this other company because they're operating independently. That is what I got to see. However, corrected.
So so their payment system locally will continue.
Yes.
So because they have a payment system. Of course, these are a topic on financial payment system and companies combined. Eh? Kate, what do you think? Do you agree with Helen or do you disagree?
I disagree. Reason being, CryptoSasa is private foreign company. Then it has a branch office locally. So when it has a branch office, it is assumed that this CryptoSasa, the shareholding is this CryptoSasa 100%, because there's no other information that says otherwise. Which means the concept of liquidation, that CryptoSasa, the Kenya branch, is the asset of the company. It will not continue because then upon liquidation, the assets of the company, including companies that they own, have to be liquidated to gain value or to bring value to the creditors of the company. So, so it will not necessarily continue or not continue. So the link that I'm sort of trying to find out is now, in that instance, the liquidator, CryptoSasa, now comes in and steps into the shoes of the shareholders and takes into the shoes of the directors. And my question there would be, now linking to what Helen has said, if the company is solvent.
No, it's not solvent. Eh?
No,
you see,
the Kenya branch, right? Its shareholders, the company shareholder.
It's a branch. It's a branch.
It is a branch, right?
Yeah.
So it is possible that the branch is solvent, but the parent is insolvent. What would happen in that instance is, because of the principles of liquidation, now the directorship of CryptoSasa Kenya would now be the liquidator. And it will only continue if the liquidator determines that it serves the interest of the creditors for it to continue. But the greater question here, and I might be complicating things, is that depending on how connected the use of the payment system was, then it could also not be able to continue. And it's the same issue we had, is it 2 years ago, with top of my head, this cryptocurrency. Anyway, I can't remember, whereby when it shut down at the head office, the ripple effect like rang across everywhere. So it still is not clear, but there will definitely be an impact. Now, the question for me is, in that scenario, will there be a requirement within the local country, within Kenya, to indicate, because even if the parent has liquidated, this local company will be run in administration. So there would need to be, in my view, a registration of the company, the branch in Kenya, being in administration and requiring that various notices and standards and thresholds for listing it as being in administration put in place. But now how to apply that and like whether that is the correct way or not, I think is my question. But there will definitely be an impact. And the impact will be, it will either also need to be liquidated depending on the mandate of the liquidator, or they will need to now enter into administration. And that one is now, it's either of those two. In administration, because now the assets of the CryptoSasa group will be run by the liquidator for the benefit of the creditors. Yeah. Now, the question as to whether now the CBK will allow for a payment system to operate in administration will be a question of what capital thresholds do they need to maintain locally. And it would be that they could put it under receivership and now under that, and it might not be able to proceed in that regard. I don't think it will be unscathed.
Yeah, so that is the correct answer is that you know, answering direct to the question what is asking,
Yeah.
whether you are able to continue utilizing the payment system locally. So that part bid, they will not. That is the answer. They will not. And then you back it with the relevant provision of the law. So you look at section 396 of the Insolvency Act. We can look at it.
Say 393.
396.
396.
Can you read?
Consequences of resolution to liquidate. Is it that one?
Yes.
On and after the commencement of voluntary liquidation of a company, the company shall cease to carry on its business except insofar as may be necessary for its beneficial liquidation. However, the corporate status and corporate powers of the company continue to have effect until the company is dissolved, when if the company's articles provide otherwise.
So even before you reach there, you remember in fact there's a question that have been asked, the process of registering a foreign company. When a company is registered, its branch in Kenya, it operates as if it is a company which have been registered in Kenya. You know that?
Yes.
That is the starting point. So the Companies and Insolvency Act applies. So when you look at section 396, so that is the starting point. Consequences of resolution to liquidate. And this applies even to all other liquidation. I know you have read not only voluntary. So the company shall cease to carry its business except as far as may be necessary for beneficial liquidation. So this is the work of the liquidator. Unaona?
Yes.
So the other section is 432. What does it say?
432. Consequences of liquidation order. Within 7 days after liquidation order is made in respect of a company, the company shall lodge a copy of the order with the registrar for registration and also lodge a copy of it with the official receiver. When a liquidation order has been made or a provisional liquidator has been appointed, legal proceedings against the company may be begun or continued only with the approval of the court and subject to such conditions as the court considers appropriate. An order for liquidating a company operates in favor of all the creditors and of all contributories of the company as if made on the joint application of all of them.
So, what are the consequences of liquidation order? So, the first of all, what we have read in 396, it ceases to
Yes.
do its operation, and all the legal proceedings
Are stopped.
ceases, ceases against the nini. Unaona?
Yes.
And this, you see this, some of these insurance companies in Kenya, when they were put under receivership, liquidation, or this is the car, what was they called? That car nini famous vehicle insurer. So
Direct line.
Yeah, so no, not even direct and is juicy. Even Blue Shield. There are many. So all the proceedings that were there continuing in court, we are stopped. So that is the first bit of the question. The second bit, so the payment system will stop. What are the steps that the local officials need to take in compliance with the law? So this point, you look at section 991. So you can go there at 991. Remember, the branch has its officials here, registers officials. So what does it 991 say? You can read.
Of with the Insolvency Act.
No. It's of the Companies Act. Sorry.
Oh, naangalia kwa insolvency haijafika 991.
991.
Companies Act. Let me see. Unless Helen, do you have it with you? Company Act.
I'm still scrolling.
Okay,
so let me project.
Utafika tusome.
Okay.
Let me project. So Companies Act. Yeah. So the relevant section is 2. So, of course, this one you read together with 432, the one you have read on Nini. So within 1 month of registered foreign company has been dissolved, or they registered in place of origin, each person who's on the other day when the company was in its place of origin, a local representative of the Kenya shall lodge with the registrar for registration of the notice of that fact. So that is the first thing. You can read with the 432 of the Insolvency Act.
Yes, 432 and 396.
Yeah, so they need to approach the registrar.
Hey, Mwalimu, section 991 these things. Like, how do you know to read all the way to 991? Yeah, this thing is tough.
It is tough.
Yeah.
So as
But
soon as
we will surmount.
Yes, you will. In fact, it is 5. It is 5. It is 995. It's not 2. If registered foreign company is placed in liquidation in place of origin, it is 995. So because it is liquidation, not registration, 9915. If registered foreign company is placed in liquidation, in place of each person on the day when the liquidation process was allowed president of the company shall within 1 month after that day, lodge with the registrar the notice to that fact. When the liquidation is appointed, notice of the appointment. So then the court shall, on application by person who is a liquidator of the company in space of origin or registrar, appoint a liquidator of company in respect of property in Kenya. Yeah. So a liquidator appointed by court under 5B shall do what? What you said, Kate, shall before distributing the company property in Kenya by advertisement, pay creditors. Yeah. So 7, if a registered foreign company have been liquidated, so first, its property in Kenya is concerned, and no liquidation have been appointed in respect to company in respect of origin. The liquidator may apply to court for directors. Yeah. So the relevant section is 5.
Yes.
Subsection 5. Yeah.
Okay.
So the trick with this question, if you want to pass anything to do with the Companies Act, anything to do with companies and insolvency, you must read the Companies Act and Insolvency Act very well, and its regulation with a tooth comb. Be there,
Mwalimu, section 991 insolvency imefika close to 800.
Yes. Yeah. Yeah. But I'm telling you, unaona hii maneno ya, there are 2 areas I'm suspecting that they will come. Foreign companies, they have tested so many things, and private companies. 2 areas. Unaona hii maneno ya public companies. Nothing have been tested on public companies. Number 2, conversions. Unaona hii conversions. The process of converting from private to public, from public to private. Those are 2 areas I'm suspecting there. It's a 2 area fertile area to be asked. So thank you very much for attending today's class. Our next class is on Monday.
Which topic? Which unit?
Commercial, question 1, 2, and 3, part 1, April 2024.
Okay.
So you have the the question paper.
Yes.
If there are any drafting to be drafted, draft and send in advance.
Okay, we'll do that, Mwalimu.
And indicate the time taken to draft.
Yes.
Yeah. So you may have a good night.
Thank you very much.
Thank you, and
you too.
Yes.
Yeah. Bye.
Bye.